Today's lecture will be on the Warren Court. The Warren Court is one of the two most influential courts in American history. Obviously, the Marshall Court established a lot of precedents, but the Warren Court reshaped American political life. For the AP Gov class, there are 5 of the required cases that come from the Warren Court. Earl Warren was an incredibly famous politician who served as Chief Justice from 1953 until 1969. He presided over what scholars call a constitutional revolution. He was a Republican appointed by Dwight David Eisenhower. Prior to that, he was governor of California for a decade. He endorsed internment there, and then he ran as vice president with Thomas Dewey in 1948, although they did not win. In 1952, he ran for the nomination of the Republican Party to be president. He lost that to Eisenhower, and Eisenhower decided that he would give him a kind of a consolation prize and appoint him as Solicitor General, the man who would argue for the government before the Supreme Court. But just before he made that nomination, the Chief Justice of the Supreme Court, Fred Vinson, died, and Eisenhower chose to then give Warren the appointment to be Chief Justice of the US Supreme Court. That single act would change history. Warren would be the last person who directly moved from elected office to the position on the court. He was still incredibly influential in the Republican Party. And in most surveys, Republicans considered him the second most important man in America. In 1955, in fact, Dwight Eisenhower considered stepping down after one term to let Warren run. But Warren made it clear that he would not resign his position as Chief Justice. The Warren Court was an interesting court because when Earl Warren joined it, the other 8 members were decidedly not in favor of expanding civil rights. Warren would lead them to a great revolution. To some degree, that frustrated Eisenhower at times, where he allegedly made the phrase that appointing Warren was the biggest damn fool mistake I ever made. The Warren Court was reviewed in a well-reviewed book by 2 great legal historians, Jeffrey Stone and David Strauss. They just published this in January of 2020. And what they see in Warren was a great movement at democracy and equality. But not everyone saw it that way. There was a movement in the mid-50s to impeach Earl Warren. This movement here is led by, as you can see on the screen, the John Birch Society, a relatively new, pretty radical far-right organization. Thus, Earl Warren would leave a legacy, but it might be tainted in some people's minds. According to Strauss and Stone, prior to the Warren Court, you had a court that was willing and decidedly, clearly, against expanding federal protection of rights. You might remember that we discussed in 1873, 76, and 1883, the court clearly decided not to expand or use the 14th Amendment's Equal Protection Clause to protect African Americans. Earl Warren, it seems, dug out a clause, a footnote, from a decision in 1938 that I've mentioned to you, the Caroline Products case. It's called footnote 4, and it was part of the writing of Chief Justice Stone. And in that footnote, the court said there's one area of time, or sort of one moment, that the court should assert itself, should be activist. And that time invoked 2 separate areas. When democracy or equality were endangered. And in that time, what you would do is protect democracy or equality from majoritarian power or abuse. And that's essentially the argument of Strauss and Stone, that the Warren Court applied footnote 4 to a series of cases that would expand democracy, equality, and individual liberty. For the rest of this lecture, then, I'm going to break up the cases of the Warren Court and look at them in 8 topics or 8 themes. Some of these I'll go through quickly. Some of them you've heard before. Some of them are part of the required AP Gov course. And some of them we'll dig into deeply in future lectures and units. So let's begin with the case that transformed America. And the case, you know, was the case of Brown v. the Board of Education. And the lead litigant, the lead attorney of that case would be none other than Thurgood Marshall. So the case of Brown, the required case that I've introduced to you, brings together 5 separate cases and focuses it on the specifics of the case in Topeka, Kansas. Of Thurgood Marshall, scholar Michael O'Donnell said, if Martin Luther King was the moral and spiritual leader of the civil rights movement, Marshall was its general, and he wanted results. Instead of making speeches, he made law. Marshall was the NAACP's top legal counsel for 23 years, 1938 to 1961. He argued 32 times before the US Supreme Court, winning 29 of them. Now, the case of Brown would hinge on a lot of foundational arguments that Marshall would use based on the denial of equality, separate but equal, but also the basic principle that the idea of separate schooling was itself constitutional. At first, the movement in the Black freedom struggle for educational rights was pushing the idea of equal funding. But Spotswood Robinson, one of the colleagues of Marshall, introduced him to a paper written over a decade earlier by Polly Murray, a female law student he had, that said they should tackle the whole system of Jim Crow. To help do that, Marshall would enlist the work of Kenneth Clark, the famous psychologist, and his study using dolls in front of young children, and to discover what the psychological impact of that would be. In this case, then, Warren got a unanimous unanimous decision to overturn the policies in, I think it was 16 or so states that allowed still segregated schooling by law. Warren's opinion was written briefly. It was written in fairly simple language. His vision was that it would be printed in newspapers and would be accessible to the average reader. Warren understood that this decision was transforming American political culture. In some ways, what I see is Warren using the decision much like FDR used the fireside chats to simply explain. And his opinion then clearly was about the impact that segregated schooling had on children of color. And he wrote very clearly that what it does is, as you see on the screen, it denotes this badge of inferiority. And he uses that term, I think, intentionally, because it was part of the majority opinion in Plessy that rejected the idea of separation in instilling a badge of inferiority. And that separate but equal has no place and is inherently unequal. In doing this, the decision thus rejects that legal principle called stare decisis, that idea that we would let past decisions stand, especially decisions that had been upheld by other courts. It also was contested because of its use of psychology. But I would suggest that you think too about the use that Brandeis did in the Muller case, when he used sociology. And in that way, we see a number of times that the impact. So I want you to think back to when we looked at textual or originalism versus living, and whether consequences and impact should matter. This case certainly would believe so. Now, beyond the case of Brown, there are major other cases that could extend the importance of the Brown decision. The first case on the list here, Bowling v. Sharp, happened on the exact same day. This was one of those 5 cases. And what this did, this was dealing with the specific issue of the District of Columbia. So because the 14th Amendment applies only to states, would schools in the district be allowed to continue to be segregated? In some ways, I see this as analogous to the debate between, or the decisions the court has to make between the case of Heller and McDonald, between the right to own a gun and carry a weapon in the District of Columbia and one in any of the 50 states. In this case, it became difficult because the 14th Amendment has the Equal Protection Clause. The Fifth Amendment does not. So Warren writes using the due process part of the Fifth Amendment and asserts that right we've talked about, a right of liberty, that guarantee of liberty, that liberty, whether it's economic liberty or liberty of persons. And thus we apply that concept to equality of education throughout the United States. At least it could not be barred by race. The case below that, Brown 2, is a hearing a year later in which the litigants came back to decide how and when do we integrate. Now, the NAACP had a great vision in their mind. It should be as soon as school year begins, September of 1955. Earl Warren had a more a broad vision, though, something that almost is, in my mind, sort of dabbling and stepping over, touching into Dr. King's beloved community. He envisioned authentic integration. That would require redrawing district lines. That would require having larger districts that might have populations of difference. That would take time. So in that decision, Warren writes that the South can desegregate, quote, with all deliberate speed. On one hand, that's rational. One doesn't want to rush a big change, but it would enable one of the greatest violations of the spirit of this decision. So if we keep going with the next case there, Cooper v. Aaron. Cooper v. Aaron was a unanimous decision. And this case dealt with, I'm going to jump ahead a slide, this case dealt with the famous case of the Little Rock Nine. Now, in the case of the Little Rock Nine, the governor of Arkansas, it's an interesting case because the governor of Arkansas took the position that, and the Arkansas State Supreme Court took the position that the Brown decision didn't apply to them. It didn't apply to them because it only decided for those 5 places. It didn't create a national dictum. In this case, you get the idea that they're arguing that you must tell Arkansas specifically. The court rejected the argument and effectively asserted Article 6 of the Constitution, the Supremacy Clause, and that it would apply throughout the nation. The challenge was, with all deliberate speed, you found a backlash. Certain parts of the South integrated pretty quickly. In Arkansas itself, a fairly moderate state, Hoxie, Arkansas, integrated before Little Rock. Fayetteville, integrated before Little Rock. And in part, that was the reason that a portion of white Southerners got really angry and had such a vicious response there. So you see a process called massive resistance, best made clear in something called the Southern Manifesto. What Southern states did then was this. They shuttered public schools. Little Rock, Arkansas, shut for an entire year in the 58-59 school year. Rather than integrate, we'll close down public schools. Prince Edward County shut down its entire public school system. They would do it for 5 full years. So where do your kids go to school then? Private academies spawned. Private academies that were not under the jurisdiction of the court decision, which applied only to schools that received public funding. They created also single-sex schools because they didn't want to risk, in an integrated setting, white girls and black boys going to school together. In the 60s, the Warren Court would come to address these inequities again. In Griffin versus Prince Edward County, after 5 years of not having public schools, after 5 years in which children were denied the right to an education, where they desperately tried within church basements, or maybe through a few Quaker groups to get an education, the Supreme Court invalidated Virginia's use of property tax abatements. If you sent your kid to a private school, you received a 25% reduction in your property tax. Effectively, that's akin to public funding of a private school. So we get the end of that system. In the case of Green in 1968, the Supreme Court uses this famous phrase that they need to root and branch segregation from American public schooling. Sadly, by 1964, 10 years after Brown, only 2% of young African Americans attended integrated schools. So they were pushing for ways to say you need to pick up the pace. And finally, in Alexander in 1969, the Warren Court ended with all deliberate speed and mandated that Mississippi begin immediately the process of desegregating its schools. Beyond the great work on desegregating schools, and by the way, by 1970, I think the number was up to nearly a third of kids attended integrated schools. Beyond the desire to integrate schools, the African American freedom struggle pushed for the integration of the totality of life. So we move to our second theme, the broad issue of civil rights. And you might recognize that the young woman on the top picture, that's Rosa Parks. The woman in the bottom picture, that's Aurelia Browder. It was her name that was on the legal filing to demand that Montgomery desegregate its buses. And after 381 days of struggle, or just before 381 days, the Supreme Court weighed in and required the city of Montgomery to integrate its buses fully. Similarly, 4 years later, in a case known as Boynton versus Virginia, the Supreme Court prohibited the segregated waiting rooms around bus terminals. That case led to the famous freedom rides that you remember. Now, during that period of the early 60s, you had a lot of, you had the wonderful sit-in movement and the freedom rides movement. That would give way to what I've told you is called the child of the storm, the Civil Rights Act of 1964. Rather than going item by item, theaters, public accommodations, parks, etc., let's have a broad case. Now, the Civil Rights Act faced a big challenge, precedents. The Civil Rights Acts of the 1870s, and even the one of 1957 was watered down. But the Supreme Court had upheld great limits to federal civil rights laws. So if you remember in 1873 and 1876 and 1883, the court held that the state and the state alone had the absolute right to determine these forms of liberties. In 1964, the Civil Rights Act was passed with important protected classes, race, sex, religion being the primary ones, Title VII and Title II. In the case that was challenged, the Heart of Atlanta Motel said, I have my property rights, I have my Fifth Amendment rights of takings clause, and I have my right to serve whomever I want. The federal government can't tell me who to serve. If you remember, the decision was written by the gentleman at the top, the concurring decision by Arthur Goldberg at the top is really important. The majority opinion uses the Commerce Clause, Article 1, Section 8, Clause 3, because the Heart of Atlanta had roughly 75% of its business come from out of state, right off the freeway. But in the concurring opinion, Goldberg extends the meaning of this. And he argues that the Civil Rights Act was not about hamburgers and hotels. Well, it was primarily about ending a system of humiliation. And he writes, it is the vindication of human dignity. So we get now an idea that suggests that part of this movement that the Warren Court is endorsing is much more than just about what Dr. King would call the negative issue of desegregation, and much more the positive affirmation of integration and acceptance. The court in the same year as Heart of Atlanta ruled in a case, Katzenbach versus McClone, which was about a local barbecue joint. Now, this barbecue joint did not serve a significant number of people from out of state, so the Commerce Clause doesn't apply there. It wouldn't serve Black customers. The Supreme Court asserted the power to deem a local business held bound by the Civil Rights Act. If we move from there to the crown jewel that I've told you about, the crown jewel in our third topic, the right to vote. Now, if you remember, the right to vote was denied from the Supreme Court in 1898 in the case of Williams, that permitted the various methods that numerous Southern states used to deny African Americans the right to vote without explicitly saying Black folks. Grandfather clauses, literacy test, poll taxes being the most common. That decision would be challenged for decades. But as you see this wonderful comment in The Need for the Ballot by King in 1957, he speaks about why the right to vote is so powerful. So the case that we know is going to be the required case is Baker v. Carr. So Baker v. Carr and all these cases, I think, deal with the important constitutional clauses. The clauses that we have to go back to are known as the election clauses. The election clauses come foremost from Article 1, Section 4. Article 1, Section 4 is the one that establishes that states will determine the manner and means about having elections. But it's important because in that clause, Article 1, Section 4, it says that states will have the primary, but then it ends with that Congress has the ultimate power to place certain restrictions on those states. So for example, states cannot say they will impose a term limit on their federal members of Congress. If we go beyond Article 1, Section 4, I think we have to ask also questions about the 10th Amendment, states' rights. We have to ask questions about the 14th Amendment and equal protection. And we have to ask Article 6, the Supremacy Clause. Ultimately, then, we look at Baker. So Baker was about an apportionment issue, an issue that we've covered before, so I'll go through quickly, that dealt with a law from 1901 in Tennessee that 60 years later seemed no longer relevant because populations had moved and there was an imbalance here. The basic thing here, the basic major point from Baker v. Carr I want you to remember is that this is a question about the nature of political questions. So if you remember when we went over the concept of Ashwander rules, at what point does the court decide that it is their role to intervene? At what point it is judiciable? This case is an assertive right that the court will intervene when equality of opportunity and democracy are endangered. And the author of the opinion, Brennan, cites past examples that they've done that. The case of Reynolds v. Sims gives us explicitly the concept of one man, one vote. South Carolina v. Katzenbach affirms and upholds the Voting Rights Act. If we move from voting then, we get to a power of individual liberty here. You might recognize these images, beautiful family here. This is the Loving family. So Mildred and Richard Loving, they fell in love one day and they would decide that they wish to wed. We will, we've gone over this issue before and we'll come back to it again. But for now, let's just understand that the Supreme Court in 1967 asserts this concept from Earl Warren, that the right to marry is part of the pursuit of happiness. And it's part of the very existence and survival of man. And if you look to the text below that, this idea that the freedom to marry or not to marry a person of another race resides with the individual and cannot be infringed upon by the state. So it's really interesting. We get the idea that there are all sorts of things that the state can infringe upon. The state can require you to vaccinate your children. The state can require you to get a license to marry. The state can require you to wear a seatbelt. There's all sorts of compelling interests. But what he's writing here is the right to marry by your choice is not the domain of the state. That we can get. But look at the part above, that the right to marry is part of the very existence and survival of man. To some degree, that comes back to the concept of dignity. Did this transform America? Well, in 1958, 4% approved of interracial relationship, 4% of whites. By 1968, 20%. Today, the numbers are, depending on the survey you look at, in the late 70s to the mid 80s. But if you look at generations that are under the age of 40. It's well over 90%, topping 95 in a lot of surveys. Beyond the right to marry, individual civil liberties were critical for this moment here. In the case of Sherbert v. Verna, this was a case about a woman who was a Seventh-day Adventist, Adele Sherbert. Her employer required her to work on Saturday. For her, that's the Sabbath. She said, I can't do that. She was terminated. So she applied for unemployment benefits. Because she refused a work condition, her state denied her those rights, the right to the unemployment compensation. The Supreme Court overturned this and upholds her free exercise right. The case of Griswold we discussed a number of times. The case of Griswold deals with executive director, Griswold, the executive director of Planned Parenthood in Connecticut. Now, Planned Parenthood and the state of Connecticut, interesting combination here. The state of Connecticut was one of only 2 states who prohibited the use of contraception. And in 1961, the pill was first marketed. So it was a revolutionary moment. Other states limited sort of sale, distribution, et cetera, but this one limited the use. So Planned Parenthood had advertised, had provided, and they were prohibited by the state. The court overturns this, and as we remember, it establishes this untextual, unwritten right of privacy. Now, it could have made a lot of arguments here. So a lot of the members of the court, this is a case where I think it's important to understand who gets to write the opinion and how they work with other members to collate and bring together, coalesce sort of a body here. Because there were some who said simply use history. So if you go back to originalism and textualism, use history as a guide. Connecticut's an outlier. There were some who argued that it should be the due process clause. And some, like Justice Goldberg, who said it should just the Ninth Amendment. Instead, the author of the opinion, this is important, it's William O. Douglas, William O. Douglas. William O. Douglas gives us those phrases, the penumbra and the emanations. The penumbra, these ideas that there are rights that are not textual, that emerge out of the rights in the Constitution, the rights out of the First, the Third, the Fourth, the Fifth, the Ninth Amendments. And I would argue the rights that emanate out of James Otis in 1761 in his writs of assistance that suggest that, that a man's home is his castle. In some way, what he's arguing is that there are unenumerated natural rights. So we've seen that in Locke, unenumerated natural rights of economic liberty. So in this case, Douglas's opinion will give us that zone of autonomy or that sense of privacy and a deeper sense of what personhood means. It was very contentious. U.S. v. O'Brien in '68, that was about a gentleman who burned a draft card, and the court upheld his right to expression and dissent. Case of Afroim v. Rusk, individual liberty. This was a gentleman who had dual citizenship in the United States and in Israel. He went to live in Israel for a few years and in fact voted in an Israeli election. Upon doing that, or soon after doing that, he came back to the United States, was denied a passport, and his citizenship in the US was revoked because he had voted in another nation's election. The Supreme Court overturns that decision, ruling citizenship is no light trifle to be jeopardized any moment Congress decides to do so. Expanded civil liberties. We also have criminal justice and rights of the accused. In the case of Katz v. the United States, this is a case that is asking, what is the definition of a search? Prior to this case, the concept of a police search was almost absolutely based in the idea of property. So in this case, the Katz case, Katz was arrested for illegal gambling after using a public phone. So in this era, phone booths and phones were outside, right? So it's a phone booth. He goes into it and he was transmitting gambling information, talking about his numbers and his bets and stuff. The FBI had attached a listening device to the wire that went into the phone booth. And they catch Katz, right? His illegal actions are recorded. He claims his rights have been invaded, his privacy has been invaded, his personal liberty has been invaded. The FBI says, we didn't go in the phone booth, we just tapped the line. The Supreme Court argues that whenever a citizen seeks to preserve as private, even in an area accessible to the public, must be constitutionally protected. That this idea is that you have a reasonable expectation of privacy. And I think that really can connect with the concept of Griswold. The right to do what you want to in your bedroom with your spouse in Griswold should be held private. The other cases deal with further issues of alleged or accused and real criminal conduct. In Matt v. Ohio, this will apply the 14th Amendment to states with the idea of exclusionary rule. The exclusionary rule means that it's popularly said to be, it's the fruit of the poison tree. This is in every cop show you see. If police obtain information without a warrant or improperly, they can't use it in court. So in this case, Delray Mapp, her home was invaded by police. They had been searching for a suspect. They thought it might have gone into her home. They appear at her door. She asks for a warrant. They say a few debated terms. Then they show her a warrant. The warrant wasn't a legitimate warrant, wasn't a warrant. They enter her home. They don't find the man, but they find obscene material, pornography. She's convicted of that in the state of Ohio, but the case is overturned and we get the exclusionary rule must be applied to states. The case of Gideon is your required case that we will cover in greater depth in our unit on individual liberties. And in the case of Gideon, just quickly, it's unanimous, but this gives the Sixth Amendment right that if you're too poor to afford counsel, one will be appointed to you by the state. The follow-up case of Escobedo says that the right to counsel, Escobedo is not a unanimous decision. The right to counsel begins before the court hearing begins, right? That is, while you're detained, it begins. Now, part of the dissent said that means as soon as you are held by police. A lot of contentious grounds there. But this all meant that the accused will have greater rights to counsel. And part of that right is expanded a couple of years later in Miranda, in which, you know, the classic Miranda warnings that you have the right to remain silent. We go from the rights of the accused, the next set of individual liberties is the right to not have religion. So it's really an establishment issue we're going to deal with here. And we're going to get to these cases when we get to our unit on religious liberty and religious establishment. But for the quick overview here, the required case is Engel versus Vitale here. And so this is the case that prohibits in public schools, although it's challenged again in various states, Maryland, et cetera, for a while, that the school day cannot begin with a publicly presented prayer. It was an ecumenical prayer, wasn't that radical, but that the student in a public setting should not have to be exposed to a religion if that person does not want that. And it doesn't matter, even if it's 100%. But this is an idea that the public school is a body of government and would be establishing that. The following year out of Pennsylvania is that you can't do it with a Bible reading either. So a prayer at the beginning and a Bible reading. In a related but different case, you get to a few years later, Epperson. Epperson, you can effectively says, is the bookend or the finale to the Scopes case of the mid-20s. This decision prohibits states from banning the teaching of evolution. So from 1968 on, public schools are allowed to teach the concept of evolution. If we go beyond the establishment cases, we move to speech in the press. So we've looked at New York Times versus Sullivan. You remember that's a case coming from the civil rights era. That's a case in which the Times published that full-page ad from the SCLC, Dr. King's organization. It was an ad very critical of a Southern sheriff, although it did not name that sheriff. It was very critical about the South's resistance to equal treatment. And yet it had at least 7 errors in it. They were mostly minor, but some of them that stood out. Sullivan sued. was about to be granted a few $100,000 case, but the Supreme Court ruled and granted expanded freedom of the press by saying that the press must have some intent of malice to be convicted of libel. We go back to US v. O'Brien, and it's the idea of the burning of draft cards. Street versus New York is not that dissimilar. It's a gentleman who was upset with the shooting in 1966 of James Meredith. He was on his one-man march then, and felt that the country didn't protect his rights, and so took his flag, burned the flag. But what he was convicted of in the state was of the words he used about the flag. And so the court upheld his right to do that. At the same time, the court upheld a number of hateful forms of speech. Stanley versus Georgia, that's more obscenity. But Brandenburg was the case that I covered when we dealt with hate speech during an earlier unit. And this is the case that would allow what many people would consider repugnant groups, like the Klan and the American Nazi Party, to speak their viewpoint. This is the case that transforms the required case of Schenck versus the United States from clear and present danger to imminent danger. So the state can only restrict your speech when there is imminent danger. It's a much stricter, and it allows much more freedom of speech than the Schenck decision would. We go from there. You get the idea that we will cover in a separate lecture. So very quickly, the idea of the Warren Court having the rights of students here. And you see my picture here with Mary Beth Tinker. In 2018, I had the great honor of having lunch with her. And in this case, students, the great statement from the court that you do not shed your constitutional rights at the schoolhouse gate. This is an idea that symbolic speech has a lot of power, and we'll look at that with student rights in this separate video in due time. The Warren Court just didn't, though, deal with a lot of expanded racial rights or equality of liberties or freedom from being imposed on with a specific religion. It really also expanded a few economic rights too, and in its own way expanded LBJ's war on poverty. So the first case I have up here is called Williams v. Lee Optical. It's a really interesting case, and it really would be a case that would be connected to economic liberty. In fact, it is with, say, Lochner, or much more about the rights of small businesses. So Lee Optical operated a chain of eyeglass stores throughout the Midwest, and they started to develop for the mid-50s a funky and a new way that they could develop a glass frame that semi-custom fit your face. But the state of Oklahoma passed a law that required all eyeglass makers to receive a prescription from an ophthalmologist, right? And so what they're doing is they're protecting one class of workers. So I've talked to you about sort of licensing laws that seem to be protecting interest groups and denying sort of that competitive world that Lee Optical came up with a new method that we could offer people a cheaper way. In this case, under the Equal Protection Clause, Lee Optical wins its case. King versus Smith deals with something that was known as man in the house rules. It's a unanimous decision. So in the early 60s, under the Great Society, Lyndon Johnson gave an expansion to the concept of welfare and provided mothers who were poor and had children cash benefits. Part of the requirement, though, that states were allowed a lot of leeway. They required the woman to not be married. It's a big debate about what that does to family status here. But then states also passed these so-called man in the house rules, that if the man was present, some disproportionate amount, or living in the house, then you would be denied the welfare benefits. So in the case of King, Miss King had 4 children. The father of the first 3 died. The father of the 4th was not in the picture. So she started a relationship with a gentleman who also had multiple children. He would come over to her place and would spend the night numerous times, right? So the state of Alabama, Selma, Alabama, withdraws her benefits here. The Supreme Court overturns these man in the house rules, arguing that you cannot deny the woman the benefit that is to go to her children because of this relationship. It sets up two classes. And it's a form of sort of cooperative federalism that we'll get to. It's an idea that says you can count the income from that gentleman to see if that informal family unit no longer qualifies for welfare, but you cannot deny it. So it's really, I think, an important protection of the poor. And it offers 400,000 children protective status then. The case below, Shapiro versus Thompson in 1969. This is a case of a 19-year-old woman, single mother, who would move from Massachusetts to Connecticut to live with her mom as she was pregnant with her second child. She went to apply for benefits, and the state of Connecticut denied her those benefits because she had not lived in the state for a year yet. And in this case, the court asserts a really interesting right. It argues for the 14th Amendment Equal Protection Clause, but in what they affirm as the right to travel. Now that phrase, the right to travel, was used by the circuit court that upheld it, and then the state challenged the circuit court. The circuit court had said that if you have this down, you will have, quote, a chilling effect on the right to travel. And that's really a debate that we have a lot about with our federal policies for social welfare that require to re-register in states. It's a chilling effect. We usually refer to chilling effects with speech, but this is a chilling effect on the right to travel. And Justice Brennan, who writes the opinion, argued that the one-year residency sets up a two-class system of needy resident families, and that the right to travel freely, in his words, is part of the nature of our federal union. Perhaps most famously then, the Warren Court will deal with this issue. This map of Pittsburgh shows you a 75 or so year old map, a little bit more than 75 years old now, 85 years old map, of redlining. This process that both banks and real estate agents would use to project where, quote, desirable places in the green and undesirable places in the red would be to live. I have a document that shows Mount Lebanon status, and it's desirable. It's very clearly homogeneous, and the no categories of who's not there are there. All right. In this case, then, you would keep then de facto segregation here. This case would be overturned effectively by what was called the voice of justice, the Fair Housing Act. So the Fair Housing Act would prohibit in renting and purchasing a place to live based on race, religion, and sex. It would later add family status and a few other areas like disability. But Congress passes something. Is that going to pass muster, right? Again, my economic rights. In the case of Hunter v. Erickson, coming really near the end of the Warren Court, affirms and upholds this. This overturns an Ohio decision, Ohio law rather. So what we find here, kids, is this. I think we find that the Supreme Court under Earl Warren expands this concept of democracy and equality. Strauss and Jeffrey Stone, they have, I think, the spot-on powerful argument there. And if we look at that, though, I want to look then to the lasting legacy of it. The lasting legacy of the Warren Court has got some asterisks, some question marks. So the case of Rodriguez v. San Antonio occurs just after the Warren Court. Earl Warren steps down in 1969, replaced not by the hoped-for nominee that Lyndon Johnson wanted. No, there was some difficulties there. And so the Chief Justice would be replaced by Richard Nixon, and Warren Burger would be appointed. In Rodriguez, this was a case coming out of Texas that sued based on unequal funding of public schools. Now, there was also a degree of ethnic and racial divisions here because it was a primarily Hispanic area. But in this case, the Supreme Court rules that there is no fundamental right to an education. The Equal Protection Clause, it writes, does not require absolute equality or precisely equal advantages. The Supreme Court effectively says that funding of education is not judiciable. It is for the legislative process within states. And in that case, we see the end to the efforts to try to equalize by class schooling. Thurgood Marshall's dissent in this case is beautiful and jarring in its prose and in his anger. So he argues, right, what he had been arguing probably for about 25 years. In my judgment, the right of every American to an equal start in life, so far as the provision of a state service as important as education is concerned, is far too vital to permit state discrimination. And echoing what he had argued in Brown, he argues that the hope for an ultimate political solution sometime in the indefinite future, while in the meantime, countless children unjustifiably receive inferior education, just may affect their hearts and minds in a way unlikely ever to be undone. In many ways, he's echoing Dr. King in Letter from Birmingham Jail, that required document. Wait almost always means never. But he also argues, he says that there's something bigger about this right of access. So in both his earlier cases based on race, and in this case based on class, Thurgood Marshall is arguing about networking and access. That part of it is not just your benefit about sitting next to someone. No. It's about the access to all like the resources that Mount Lebanon have, the access to counselors, college opportunities. And when you think about it that way, there is a great divide, both class and race, into that access. Plier le Vidot, I think, is the continued lasting legacy. Remember, this case will use the person element of the 14th Amendment and says that even undocumented immigrants in public schools must be educated. The Warren Court does, I think, have an impact in hearts and minds. So you can see that there was a significant growth in the desire among white folks for integrated schooling. And that's an impressive benchmark there. You can see the chart I was hinting at yesterday. From 1954 to 1964, only 2% of Black students in majoritarian white schools. By 68 or 70, by the end of the decade, a third. Then you can see the peak of integration is roughly 1989, and 1989 is when we see the slide downward. Part of that is because of the more conservative decisions of the Burger Court and then the Rehnquist Court. During the Burger Court, there was going to be one means that we could deal with this because de jure segregation was gone. You can't discriminate based specifically by law on race, and you can't deny by housing. But you still had de facto, and you had people living in segregated housing developments. So we have the case of Milliken v. Bradley in 1974. And this case was a simple case that said virtually a predominantly Black city district was going to be integrated with a predominantly white suburban district. In this case, the Burger Court rules against the efforts of the state of Michigan to integrate this school system. And the decision is that districts cannot cross district lines to integrate. So you can integrate or move kids within a district, but not between districts. That case would then be decided and limit the chance to have an integrated setting. In the late part of the decade, 1978, this case we will look at later again. Alan Bakke was denied admission to medical school in the UC system. It was a system that had a strict quota in it, and that system of quotas for the number of minority candidates would be struck down. That decision would be challenged and debated a lot. And in its ruling, it is Justice Powell that writes the ruling, and he describes a plus factor. So the Bakke decision strikes down quotas for admissions to college, does not reject or deny colleges the right to use what are known as plus factors, and race being one of them. Beyond the idea of integrated schooling, the Warren Court's positions faded in a few other areas. I'm going to skip that case. In the case of housing, while in 2015, with Anthony Kennedy's fifth vote, the Supreme Court upheld the right of using disparate impact. That's the idea that says we can't prove every individual is using racial bias, but we can look at the data and the numbers, to its being overturned in the Trump administration. No court decision, just a policy decision. And then you remember in the voting rights issue. In Shelby versus Holder, we have the 2013 decision that greatly limits, or as people like John Lewis would say, guts the Voting Rights Act, so that pre-clearance is virtually removed. Now, John Roberts says we are a far different nation. And to that point, I think he has a point. But the resulting actions, from voter ID laws to waiting periods, to limits on in-person voting and out-of-person distance voting, suggest that we're still struggling with the same struggle that occurred in Selma, in Montgomery, and in 1965. In the case of Shelby, John Roberts argued that we decide this based on the concept of equal sovereignty of the states. I've mentioned this gentleman, Judge Richard Posner. He was a Reagan appointee to the Seventh Circuit. He has since retired. He has a great use of words. He uses words wonderfully. His opinions are a joy to read. In his response, he has no legal power here, but in his response to the case of Shelby, he writes, "There is no doctrine of equal sovereignty of the states." To some degree, I think Richard Posner is saying that folks who dabble in originalism exit it at certain points when it is convenient. So the Warren Court will stand as one of the most influential courts in American history, perhaps the most. We will pick up with part of that legacy in future lectures.